afternoon to all of you. I, Jocelyn Dang, together with my groupmates Mark Anthony Liig and J. Jose Sabado. And we will be discussing about Introduction to Philippine Criminal Justice System. Criminal justice system is the machinery of the state or government which enforces the rules of conduct necessary to protect life and property and maintain peace and order. It is the machinery that the society uses in the prevention and control of crime. It is also the process of linking 5 pillars of the CGS: the police, the prosecution, the court, the correction, and the community together as to achieve an interrelated scheme of reciprocal responsibility in the approach to community development. It also reveals that each component has a distinct sequential role to perform within the system. It is a social institution and a system. When we say it is a social institution, it is the system that attempts to meet the society's needs for law and order. And a system, it is the criminal justice, depends on due process involving the 5 pillars. Two types of court systems of the world. First one is the adversarial. It is the legal system in which the prosecution and the defense compete against each other and the judge serve as a referee to ensure fairness to the accused and the legal procedure are followed. Second one is the inquisitorial. The court or a part of the court is actively involved in investigating the facts of the case. What are the differences of the two? As to presumption, the adversarial assumes the accused to be innocent until proven guilty, while the inquisitorial approach assumes the accused to be guilty until proven innocent. As to the burden of proof, the adversarial approach places the burden on the public prosecutor to prove the guilt of the accused, while the inquisitorial approach places the burden to the accused in proving his innocence. As to the emphasis, the adversarial approach places emphasis on the process, while the inquisitorial approach places the emphasis on the conviction of the accused. Nomenclatures given to the person being processed in the criminal justice system. Suspect is on during investigation at the police stage. Respondent is during determination of probable cause at the prosecutor's office. Accused is when case is filed in the court. Convict is when the court convicted the person and judgment has been rendered. Criminal is upon undergoing all the processes when the person has served the sentence. Kinds of due process. First is the procedural due process. It is the one which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. Substantive due process. This requires the intrinsic validity of the law in interfering with the rights of the person to his life, liberty, or property. Two aspects of the criminal justice system. The first one is the formal justice system. It consists of the first 4 pillars of the criminal justice system, and they are part and parcel of the formal component of government. Second one is the informal justice system. It is the community pillar. This is composed of the private sector made up of citizenry. Next is the criminal justice system model. First one is the crime control model. It is based from the idea that the most important function of the criminal justice system is the repression of criminal conduct. The second one is due process model. It has the feature of obstacle course. Each of the stage of the CGS from arrest, prosecution, through the court's disposition of the accused is designed to present formidable impediments to carrying the accused any further along in the process. What are the differences between these two models? As to quality control, crime control model emphasizes on efficiency and productivity, while due process model put emphasis on reliability. As to primary concern of protection, crime control model concerns are the protection of individual freedom and general maintenance of liberty, while due process model concern is the collective right of the society that must take precedence over the rights of individual. As to assumption of guilt and innocence, crime control model presumed an individual guilty until proven innocent, while in due process model, people are presumed innocent until proven guilty. As to the promotion of treatment punishment, crime control model promotes punishment, while in due process model promotes treatment. Next one is the Philippine criminal justice system, to be discussed by J. Jose Sabado.
Okay, next topic is the 5 pillars of the Philippine criminal justice system, and we have here the law enforcement pillar, the prosecution pillar, court pillar, correctional pillar, and lastly the community pillar. So under the law enforcement pillar or the police, this refers to the entire organization of the law enforcement itself. So police are the forefront of the criminal justice system. So the law enforcement is deterrent and preventive activity. It consists of patrolling to supervise conduct, investigating the identity of the offenders, and recover stolen property, and warning or arresting those who are probably guilty of criminal behavior. So its goals are all aimed toward the prevention of crime and disorder, prevention of peace, and the protection of life, properties, and individuals' freedom. So aside from the Philippine National Police as an agency under the Department of Interior and Local Government or DDILG, we have here also other agencies which consist the law enforcement pillar. So we have here the National Bureau of Investigation under the Department of Justice. We have here also the Dangerous Drugs Board and the Philippine Drug Enforcement Agency or the PDEA. And we have here also the Bureau of Customs under the Department of Finance and many other agencies. And we have here kinds of policemen. We have traditional policemen, which is the men in uniform, walking and patrolling, observing persons and things to accomplish crime prevention mission. And we have the contemporary policeman, which is the materialistic, arrogant, college-educated agent of a person in authority whose insight of public service is that for the public to serve him as his source of extra income. So the police is mandated to exercise peace in order, to enforce all laws and ordinances, investigate and prevent crimes, exercise general power to make arrest and detain an arrested person, issue licenses, and supervise and control the training, and lastly perform such other duties and exercise all other functions as may be provided by the law. And we have here the role of police in the system. So first is to make arrest. So arrest is defined as the taking of person in custody in order to be bound to answer for the commission of an offense. And we have two kinds of arrest by virtue of warrant and warrantless arrest. So in the arrest by virtue of warrant, it shall be the duty of an officer to whom the warrant of arrest is delivered to the defendant, and without the unnecessary take the person arrested before the judge who issued the arrest. And uh, in making an arrest by virtue of warrant, the officer shall inform the person to be arrested of the cause of the arrest and the fact that a warrant has been issued for his arrest, except when he tries to flees, or forcibly resist before the officer has the opportunity to inform him of such information will imperil the arrest. After such arrest is done, if the person requires it, then the warrant shall be shown to him as soon as practicable. Next is we have the warrantless arrest. So a peace officer or a private person may, or without a warrant, arrest a person in the following circumstances. First is when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Next is that when an offense has in fact just have been committed, and that he has a personal knowledge about the fact, indicating that the person to be arrested had committed it. And lastly is that when the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving his final judgment, or is confined while his case is pending, or has escaped while being transferred from one confinement to another. Aside from those, we have also the role of the police in the system to gather and preserve evidences, to transmit the records of the case to the court or to the prosecutor, and lastly, to appear and testify in the court. And next is we have two components of the police based on the PIL principle. Formal, it consists of the PNP uniformed personnel, the NBI, the LTO, and other government law enforcement agencies. And informal consists of the citizens or private sector. Therefore, we have what the so-called citizens' arrest. So next pillar is we have the prosecution pillar. It is the process or method whereby accusations are brought before the court of justice to determine the innocence or guilt of the accused. So the role of the prosecutor is to serve as the lawyer of the state or the government in criminal cases. So a prosecuting attorney by nature of his office and is under no compulsion to file a particular criminal information where he is not convinced that he has evidence to back up its averment, or that the evidence at hand points to a difference. The prosecutor, in deciding whether to prosecute, is responsible for evaluating the evidence the police have gathered and decide whether it is sufficient to warrant filing charges against the alleged violator. And next is the prosecutor service is made up of the provincial and city prosecutor, chief state prosecutor, assistant city or provincial or state prosecutor, and etc. And we have here the prosecutorial discretion. So typically enters the picture immediately after the arrest when the police investigators' reports are forwarded to the prosecutor for review. So this is also known as a selective prosecutor. So just like what I said earlier, the prosecutor must make an evaluation whether the evidence at hand is gathered by the police officer need to make an information. And we have here preliminary investigation. So this is an inquiry or proceeding for the purpose of determining whether there is a sufficient ground to engender a well-founded belief that a crime has been committed. So take note that when a person is lawfully arrested without a warrant involving a case which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with the existing rule. So that should be noted in this prosecutor's role. So here, yes, we have the inquest. So an inquest is an informal summary investigation conducted by a public prosecutor in criminal cases involving a person arrested and detained without the benefit of a warrant of arrest. And we have here arraignment. So it is the legal mechanism whereby an accused is brought before the court. And the plea bargaining, the process of discussion of an agreement between the prosecution and the defense. So plea bargaining is an informal. Plea bargaining is no formal, informal. It is off the record process controlled by the prosecutor and defense counsel without a participation by the court or the accused. So therefore, no formal rules to guide the lawyers in arriving at a plea bargain that is mutually satisfactory, fair to the defendant, acceptable to the court, and in the best interest of the public. So that is the plea bargaining. So the third pillar is the court, and it is the body to which the public administration of justice is delegated, being a tribunal officially assembled under the authority of law at the appropriate time and plea for the administration of justice. So we have here a court and judge. So a court is an incorporeal entity composed of one or more judges, and judges is a public officer so named in his commission and appointed to preside and to administer the law in a court of justice. It has a personality separate and distinct from the men who composed it. We have here also courtroom work groups. So court administrators. These government employees are usually appointed by state court of last resort to act as a statewide court administrator. Court clerks, they are the assistant of the judges. They are responsible in maintaining the court records, preparing daily calendars, calling cases before the judge, controlling evidence in court, and collecting fines and other court costs. Bailiffs, they perform variety of duties including maintaining order in the court, announcing judge entry into the courtroom, calling witnesses, and controlling defendants and supervising juries. Court reporters, sometimes they are called to as the court stenographers. These people report everything that is being said in the court. And witnesses, we have here two kinds of witnesses, either lay witnesses or expert. So the lay witnesses testifies in court about something he observed in a crime, while an expert witnesses provides the court with information on a special topic relevant to evidence presented in court. So usually these expert witnesses are professionals. And we have three important functions of courts. First is to resolve disputes, provide protection from illegal actions by government and individuals, and lastly, occasionally resolve disputes of great political and social significance. And we have the basic court system in the Philippines. We have the first level courts. So this includes the MTC, or the municipal trial courts in provinces or in cities, the municipal circuit trial courts, and metropolitan trial courts. So they try and decide only particular types of or classes of cases specified by the law. So under the under the jurisdiction of the first level courts is that they try and decide the all violations of city and municipal ordinances committed within their respective territorial jurisdiction, and all offenses within the imprisonment not exceeding 6 years, regardless of the amount of or the fine. And we have the second level courts. They are what they call the regional trial courts. Like the first level courts, the RTC are also trial courts. They are courts of general jurisdiction. They try and decide not only the particular classes or kinds of cases assigned to them by law, but also those are not otherwise within the jurisdiction of the courts of first level. RTC also exercise appellate jurisdiction to review cases appealed from the lower courts. And the regional trial court exercise exclusive jurisdiction in all criminal cases that are not within the jurisdiction of any court punishable with imprisonment exceeding 6 years, regardless of the amount of fine. So the RTC have exclusive appellate jurisdiction in all cases decided by the lower courts in the respective territorial jurisdiction. And the third level court is the appellate court, or the court of appeals. It is essentially an appellate court reviewing cases appealed to it from the regional trial court. It may review questions of facts or miss questions of fact of law. Appeals to it as regard cases divided by the RTC in the exercise of original jurisdiction are a matter of right, but appeals with respect to the cases decided by the RTC in the exercise of its appellate jurisdiction are a matter of discretion. So in each jurisdiction, original jurisdiction to issue writ of certiorari, prohibition, mandamus, habeas corpus, quo warranto, and auxiliary writs and processes. So they have exclusive appellate jurisdiction over final judgment, resolution, or orders of the RTC. And the fourth level courts are the Supreme Courts, which is the highest court of the land. It is also a review court. It is the court of the last resort, for no appeals lies from its judgment and final orders. In the context of the integrated judicial system, it exercises appellate jurisdiction over cases decided by the Court of Appeals or Regional Trial Court. So, appeals in the Supreme Court are never a matter of right. The only exception is when the penalty of death, reclusion perpetua, or life imprisonment have been imposed by either RTC or Court of Appeal. So indeed, when the death penalty is imposed, the case automatically goes up to the Supreme Court for review, even if the accused does not appeal. So aside from those courts, we have here also the Shara District Courts. So the Shara District Court is equivalent to the Regional Trial Court. So a Shara District Court is of limited jurisdiction. It was created under the Presidential Decree number 1083, and it decide cases falling with exclusive jurisdiction of the Shara District Courts primarily pertain to the family rights and duties, as well as the contractual relationship of Filipino Muslims in the Mindanao. And we have also the Court of Tax Appeals. It has exclusive appellate jurisdiction over the following: decision of the Commission Commissioner of the Internal Revenue involving dispute assessment, refunds of internal revenue taxes, fees, or other charges and penalties imposed in relation thereto, other matters arising under the National Internal Revenue Code or the other laws administered by the Bureau of Internal Revenue. So, aside from those, we have also the Sandigan Bayan. So, Sandigan Bayan is a special court of the same level of the Court of Appeal and processing all the inherent powers of Court of Justice. To be known as the Sandigan Bayan is hereby created, composed of presiding justice and 14 associate justice who shall be appointed by the President. It is also called and has jurisdiction to try and decide criminal cases involving violations of Republic Act number 3019 as amended, otherwise known as the Anti-Graft and Corrupt Practices Act, the Republic Act number 1379 and Chapter 2 Section 2 Title 7 Book 2 of the Revised Penal Code, where one or more of the accused are officials occupying the following position in the government, whether in permanent, acting, or interim capacity, and the time of the commission of the offense. And lastly, we have the family court. So the family courts are created under the Family Courts Act of 1997, who shall have exclusive regional jurisdiction to hear and decide the following cases. So criminal cases where one or more of the accused is below 18 years old of age but not less than 9 years old. And cases against minors cognizable under the Dangerous Drugs Act, violation of Republic Act 7610, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation, Discrimination Act, and cases of domestic violence. So we have here jurisdiction. We have here the general, exclusive, concurrent, limited, criminal, civil, and up.
So our next topic is the jurisdiction of courts, and we have here the number 1, municipal trial court, or the metropolitan trial courts, or the municipal circuit trial courts. They are known as the first level of courts, formerly known as the inferior court, and generally it has jurisdiction over criminal cases where the imposable penalty is 6 years imprisonment or below. And any cases that has a penalty of 6 years imprisonment or below, municipal trial court has this jurisdiction to try and decide. For example, is the less serious physical injuries, which is punishable not higher than 6 years imprisonment. And another is the regional trial courts, a second level court formerly known as the court of first instance, and generally it has jurisdiction over criminal cases where the imposable penalty is more than 6 years imprisonment. For example, is the parricide, which is punishable by reclusion perpetua, 20 years and 1 day and 40 years. And likewise, regional trial courts has its jurisdiction over criminal cases are said to be general, meaning that if the cases are not within the jurisdiction of any courts, the same are lodged within the RTC. If the case or cases to be tried is not under within any other court's jurisdiction, the regional trial court may get it. And that's for the regional trial court. And we move on to the Court of Appeals. Court of Appeals has an original jurisdiction to issue writ of certiorari, prohibition, mandamus, habeas corpus, quoranto, and auxiliary writs and processes. Court of Appeals is vested with jurisdiction over appeals from the decisions of the Regional Trial Court or the RTC and certain quasi-judicial agencies, boards, or commissions. Also, connection with that, a court of appeals is a court who accepts appeal or has the jurisdiction over appeals coming from the lower courts. And next is the Supreme Court. Supreme Court is known as the highest court of the land. It is a review court and it is the court of the last resort, for no appeals lies from its judgment and final orders. In the context of the integrated judicial system, the system, it exercises appellate jurisdiction over cases decided by the Court of Appeals or Regional Trial Court. And as you all know, Supreme Court review and revise, reverse, modify, or affirm an appeal or certiorari, final judgment, and decrees from the lower court. And next is the Sharia District Courts. And it is Sharia District Courts is equivalent to regional trial courts, and which were established in certain specified provinces in Mindanao where the Code of Muslim Personal Laws of the Philippines is being informed. Sharia District Courts is only found in Mindanao because they have their own laws. The Sharia District Court is of limited jurisdiction and it was created under Presidential Decree number 1083. Cases falling within the exclusive jurisdiction of Sharia District Courts primarily pertain to family rights and duties as well as contractual relations of Filipino Muslim in the Mindanao. That is for Sharia District Courts. And next is the Court of Appeals. The Court of TAC Appeals was created under the Republic Act number 1125. It is a special court of limited jurisdiction, and Court of Appeals has an exclusive appellate jurisdiction over appeals from the decision of the Commissioner of Internal Revenue and the Commissioner of Customs on certain specific issues. Court of Appeals is composed of 3 judges, 1 presiding judge, and 2 others as members, and all of them are appointed by the President. Next is we have here the Sandigang Bayan. Sandigang Bayan is a special court of the same level as the Court of Appeals and possessing all the inherent powers of a court of justice, and is hereby created, composed as presiding justice and 14 associate justice who shall be appointed also by the President. And moreover, Sandigang Bayan is a special court tasked to handle criminal cases involving graft and corruption and other offenses committed by public officers and employees in connection with the performance of their function, or the so-called service-connected duties. That is for Sandigang Bayan. And last is the family courts. The family courts are created under the Family Court Act of 1997 and has an exclusive original jurisdiction to hear and decide cases like cases of domestic violence, violation of RA 7610, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act. Another is the cases against minors cognizable under the Dangerous Drugs Act as amended. And last is Last is the criminal cases where one of or more of the accused is below 18 years of age but not less than 9 years of age at the time of the commission of the offense. That is for the family courts. And we move on to the stages in proceedings. We have here the arraignment, and arraignment is the stage in criminal prosecution which consists of reading to the accused in open court of the complaint of or information charging him with an offense and furnishing him a copy thereof, including lists and witnesses, and asking him whether he pleads guilty or not guilty, and reading the same in the language and dialect known to him. It must be understood by the person you are trying to yung under arraignment. That is for the arraignment. And move on to the pre-trial. Pre-trial is an informal trial which precedes the regular trial of the case, primarily intended to expedite the proceeding whenever the accused and his counsel agree, whereby the court shall conduct pre-trial conference without impairing the right of the accused. Next step is the trial. The formal investigation of the matter in the issue with respect to the action before a competent court for the purpose of determining such issue that involves the guilt or innocence of the accused. That is for the trial. And next step in the proceeding is the promulgation of judgment. And the judgment is promulgated by reading it in its presence of the accused and any judge of the court in which it was rendered. However, if the conviction is for a light offense, the judgment may be pronounced in the presence of his counsel or representative. And when the judge is absent or outside the province or city, the judgment may be promulgated by the clerk of court. And promulgation and absentia, there are two instances when judgment. Number one is that when the judgment is for a light offense, in which case the accused counsel or representative may stand for him. Another is that in cases where they despite due notice to the accused or his bondman or warden and that's for the promulgation of judgment. And next is the new trial or reconsideration. And in here, any time before a judgment of conviction becomes final, the court may, on motion of the accused or its own instance, but with the consent of the accused, grant a new trial or reconsideration. And in order to be granted new trial or reconsideration, there must be the ground. One is that errors of law and irregularities prejudicial to the substantial rights of the accused have been committed during the trial, and that the new and material evidence has been discovered which the accused could not with reasonable diligence have delivered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. And last is the appeal. And at any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. And where to appeal? To the regional trial court, of course, in cases decided by metropolitan trial court, municipal trial court in cities, and municipal circuit trial court. And another where to appeal is to the Court of Appeals or the Supreme Court in the proper cases provided by law, in cases decided by the regional trial court. Lastly is to the Supreme Court in cases decided by the Court of Appeals. And we move on to the fourth pillar of the criminal justice system, which is the correction. And we all know that corrections is known as the weakest pillar of the criminal justice system. And correction, as defined, is the branch of administration or criminal justice charged with the custody, supervision, and rehabilitation of offenders. The function of corrections is to reform and rehabilitate offenders. And also responsible for the following through institutional or community-based programs like maintaining institutions such as prison, jails, halfway houses, and others. Another is that by protecting law-abiding members of society, by keeping sentenced offenders from preying on society, better known as the isolation. Another is the reforming offenders by rehabilitating and reassimilating them into mainstream of society and helping them lead a normal life after release. Another is that deterring crimes. Experience in prison or jail and fear of denial of liberty will influence inmates and potential offenders to lead law-abiding lives. And lastly is the reintegration of the offender to the community, which is the most important and crucial. We move on to the institutional corrections. The key agencies responsible for this are the following. We have here the Bureau of Corrections, and Bureau of Correction, or known as the BUCOR, is under the Department of Justice and responsible for the treatment and rehabilitation of national prisoners who are serving sentence or of more than 3 years. And there are 7 correctional facilities located all the country which are under the direct supervision of the Bureau of Corrections, and they are the following. Number 1 is the National Penitentiary, which is known as the New Bilibid Prison located in Metro Manila. And New Bilibid Prison is the main insular penitentiary designed to house the prison population by the Philippines. And as you know, this is maintained and supervised by the BUCOR. Maintained by BUCOR and supervised under the supervision of the Department of Justice. And National Penitentiary has 3 security compounds, or New Bilibid Prison has 3 security compounds, namely Maximum Security Camp, Medium Security Camp of Camp Sampaguita, Minimum Security Camp of Camp Bukang Liwayway. Another is the Correctional Institute for Women, which is located in Mandaluyong, Metro Manila. And Correctional Institute for Women, or known as the CIW, is the only institution for the confinement and rehabilitation of female offenders, and it is administered by a penal superintendent. Another is the prisons and penal farms. You have here the Iwahig Prison and Penal Farm located in Palawan, Leyte Regional Prison located in Amboyog, Leyte, Sablayan Prison and Penal Farm located in Sablayan, Misamis Occidental, San Ramon Prison and Penal Farm located in Zamboanga del Sur, and Davao Prison and Penal Farm located in Davao del Norte. And these are administered and managed by the penal superintendents. Another key agency is the provincial jails, which are administered and supervised by the respective provincial governments. In provincial inmates who are serving sentence from 6 months and 1 day to 3 years are confined in these jails. And next is the Bureau of Jail Management Penology, known as the BGMP. It's under the supervision of Department of Interior and Local Government, known as the ILG, which administer and control municipal and city jails. And the inmates confined in these jails are serving sentence of not more than 6 months imprisonment. That's for the BGMP. And we move on to the national non-institutional corrections, known as the community-based correction. It involves the reformation and treatment of offenders outside correctional facilities and are community-based. The community-based alternatives to imprisonment do not include pretrial diversions, which in the Philippines setting take the form of case disposition under the barangay justice system, release on recognizance, bail, pretrial, conference, and imposition of fines. And we have here DK agencies responsible for non-institutional corrections, and they are as follows. We have here the Parole and Parole and Probation Administration for adults. And this Parole and Probation Administration is mandated to conserve and or redeem convicted offenders and prisoners who are under the probation and parole system. Next is the Board of Pardon and Parole and Conditional Pardon. Conditional pardon is a pardon given with conditions attached. And under these forms of release, prisoners who no longer need institutional treatment are released and given the opportunity to be reintegrated in the community. It is the President of the Philippines who grant conditional pardon upon recommendation of the Bureau of Parole and Pardon and Parole. Next is the Department of Social Welfare and Development, so known as the DSWD. And provision of youth offenders, I should say. Youth offenders are dealt with in accordance with the provisions of the Child and Youth Welfare Code. This code provides that the court shall suspend all further proceedings and shall commit the minor to the custody of Department of the Social Welfare and Development or any training institution operated by the government until he shall have reached 21 years of age. This is for the DSWD. And we have here the Rehabilitation Services Treatment Program. The Philippines prison system adopted two approaches in treating criminal offenders. These are the institutional-based treatment programs and the community-based treatment programs. And the treatment of inmates shall be focused on the provision of services designed to encourage them to return to the fold of justice and enhance self-respect, dignity, and self-responsibility. And we have here some of the treatment program. Number one is the institutionalized treatment programs, like provision for basic needs of inmates, health services, education and skills training, religious services, guidance and counseling services, recreation, sports and entertainment, work programs such as livelihood projects, visitation services, and mail services. Another is the community-based program. We have here under community-based program, we have here the probation. Probation is a disposition where a defendant, after conviction of an offense, the penalty of which does not exceed 6 years of imprisonment, is released subject to the condition imposed by the releasing court and under the supervision of a probation officer. Next is the parole. Next is the parole. It is the process of suspending the sentence of the convict after having served the minimum of his sentence without granting him pardon and prescribing the terms upon which the sentence shall be suspended. Convict after served the minimum of his sentence. This is for the parole. And next is the pardon, an act of grace extended to prisoners as a matter of right, vested to the chief executive, which is the president, as a matter of power. And we have two types of pardon. Number one is the conditional pardon, which is a pardon given with requirements attached. And another is the absolute pardon, which is a pardon given without any conditional attached. Another is the amnesty. Amnesty is a general pardon extended to a group of persons such as political offenders purposely to bring about the return of dissidents to their home and to restore peace and order in the community. Last is the commutation. This is an act of the president changing, reducing a heavier sentence to a lighter one or longer term into shorter term. It may alter death sentence to life sentence or life sentence to a term of years. And under commutation, it does not forgive the offender but merely to reduce the penalty pronounced by the court. And we move on to the justification of punishment. Number one is the retribution, and retribution is punishment of the offender was carried out in the form of personal vengeance, Since retaliatory acts result in the infliction of greater injury, the retaliation was later limited to the degree of injury inflicted, giving rise to an eye for an eye philosophy. For retribution, eye for an eye philosophy. Next is the expiation or the atonement. This is also in the form of group vengeance, as distinguished from retribution, where punishment is exacted publicly for the purpose of appeasing the social group. This is atonement is done publicly, punishing the offenders, giving the community as a sense of moral superiority, assurance that virtue is regarded after all. Next is the deterrence or exemplarity. Is the punishment is giving lesson to the offender by showing to others what would happen to them if they violate the law. There is the protection. It is by placing offenders in prison so that the society is protected from further criminal depredations of criminals. Last is the reformation. It is the society's interest can be it is the society's interest can best served by helping the prisoner become a law-abiding citizen and production upon his return and to the community by requiring him to undergo intense program of rehabilitation in prison. It's for reformation. And we move on to the fifth pillar of criminal justice system, which is the community. And the community as one of the component of criminal justice system of the Philippines includes but not limited to the individuals, private groups, and public entities who when performing or involved in related criminal justice activities becomes part of the system. Thus, prevention and control of crime is not only the sole duty responsibility of the government, particularly the fourth components of criminal justice system. And we move on to the components of the community pillar. We have here the home. Home has been well called the cradle of human personalities, for in it the child forms fundamental attitudes and habits that endured throughout his life. Dito nagsisimula mag-isip ang bata daw. And we move on to the next is the school. The school is strategic position to prevent crime and delinquency. This is so because the school exercises authority over every child who is of school age. It receives him when he is young, observes, supervises, and teaches him for many hours each week during some of his most impressionable years. And next is the church. It is an acknowledged fact that the importance of the church in the prevention and control of crime is beyond compare. It is the church of any denomination which points out to the faithful their relationship to God and their fellow men, and who by work and example leads them to live a moral life. Next is the government. The government is the duly constituted authority that enforces the law of the land, and such it is most powerful institution as far as control of the people is concerned. Respect for the government is influenced by the respect for the people running the government. And when the people see the public official employees are first ones to violate the law and refuses to obey it if they lose respect to the government. And next component is the mass media and radio broadcasting. So we all know mass media and radio broadcasting are considered the best instrument for information dissemination and the best source of knowledge for the public. It is true that the mass media and radio broadcasting where public opinions are formed, and that is where their influence lies. Another component is the other community agencies, stating that man composes the nation, and in order for the nation to continue existence, its constituents have to police themselves, set up rules and regulation for themselves, guide and educate inhabitants because of this systematic. That is because without Without rules and regulations, we are just like dogs, animals, just like that. So that's why we need to set up rules and regulations for ourselves, so that we will be we will be in order to govern us. That's why we need to set up rules and regulation in order for ourselves to be governed by it. And last component is the barangay. And barangay, in here, the barangay captains, peacekeeping responsibilities, and to act as auxiliaries of the law, being considered person in authority, while the other barangay leaders are deemed agent of person in authority. In effect, the barangays, through the respective barangay captains and other barangay leaders, are involved in law enforcement tasks and also other aspects of criminal justice system. Because of their peacekeeping responsibilities in the exercise of their limited statutory police power, it would be necessary that barangay captains, leaders, and members be motivated, organized, trained, and coordinated, supervised, and even compensated. That is for the barangay. The last component of the community pillar.